All right, so I'll turn it over to the judges now.
Great. Hello, everybody. Welcome, Alabama. My name is Candida Steele, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country and have been a judge for this program for the past 20 years. I can't believe it's been that long. And it's been a highlight of my year every year. So welcome, and I hope you enjoy it as much as we do. Richard?
Hello, my name is Richard Leiter. I'm a professor of law and director of the Law Library at the University of Nebraska College of Law in Lincoln, Nebraska. I've been judging state competitions for about 15 years. Have thoroughly enjoyed it. This is my first opportunity to judge the top guns, and I'm looking forward to hearing from you soon.
All right, good afternoon. War Tide and Roll Eagle. I don't know what to say, what else to say. So I am Lieutenant Colonel Kurt Mavis. I'm an attorney with the United States Air Force, currently in Colorado Springs, teaching at the Air Force Academy. But my first assignment was down at Maxwell Air Force Base in Montgomery, Alabama. So not home, but somewhat home to me. That's how I know to not put those together correctly, because you never know who you're going to come across. So looking forward to meeting you all, and also tell us where you're from in Alabama.
Hi, we're from Vestavia Hills. We're high school seniors. I'm Walt Phillips, and I'll be attending Washington and Lee University next year, planning on studying engineering and economics.
Hi, I'm Carson Hughes. I'll be going to Mississippi College next year, where I'll major in English and economics.
Hi, I'm Ethan Moavra. I will be attending Auburn University next year, studying chemical engineering as a precursor to med school. Our teacher is Miss Amy Maddox, and we are really excited to be here today. Thanks for having us.
Great, we're thrilled to have you here. And as you would not be surprised, what we're doing is question number 2 in Unit 5, and I'll read that for the record here. Quote, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty?" You may begin.
All right, thank you. Half a loaf is better than no bread. If we cannot secure all our rights, let us secure what we can. These lines, penned by Thomas Jefferson to James Madison, exemplify the importance of the Bill of Rights. During the heated ratification debates of Virginia and New York especially, many of those opposing the new Constitution advocated for one addition, a Bill of Rights. We agree with Jefferson's sentiment. All people are entitled to a Bill of Rights. We define a Bill of Rights as any original legislative text that aims to limit the scope of governments through protecting individual freedoms. For example, the First Amendment explicitly states Congress shall make no law, threatening religion, speech, assembly, petition, and the press. The impact of the Bill of Rights has only increased since the founding, with the incorporation through the 14th Amendment Due Process Clause extending protections against state and local governments. A few nations, such as Australia, have no explicitly codified Bill of Rights, yet continue to have a thriving democracy. As Madison warned, men are not angels, and therefore, without an explicit Bill of Rights, these nations arguably risk expanded encroachment of government power over the lives of their citizens.
The U.S. Bill of Rights refers exclusively to the National Bill of Rights, drafted, organized, and edited by Madison himself. However, each state possesses a Bill of Rights, whether it is overtly listed like our National Bill of Rights or embedded in the text of its respective state constitution. The importance of the state bills of rights, as opposed to the National Bill of Rights, is that states can guarantee citizens' rights more tailored to their needs or state interest. While there can be tension with the Supremacy Clause, the 10th Amendment, in parts of Article 1, reserves certain powers exclusively to the states, allowing for the so-called laboratories of democracy Justice Brandeis referred to in New State Ice Company v. Liebman in 1932. For example, Wyoming granted women's suffrage long before the ratification of the 19th Amendment. Likewise, Massachusetts Supreme Court found the state ban on same-sex marriage to be unconstitutional in 2003, 12 years before Obergefell v. Hodges. More recently, states including Colorado and Oregon have fully decriminalized marijuana on the state level. This kind of state-led action can motivate even the most stagnant Congress to tackle similar policy questions at the national.
The first 10 amendments primarily outline negative rights, or rights that oblige inaction. Given that the U.S. was founded on Lockean principles of limited government, we hold that negative rights are far more effective at preventing excessive government action and therefore preserving our liberties. Furthermore, we hold that positive rights can be in direct conflict with the limited government designed by the framers, as they require government intervention to provide rights. The First Amendment is glaringly negative. In cases such as Tinker v. Des Moines, Texas v. Johnson, and National Socialist Party versus Village of Skokie, the court obliged or forced inaction from the higher power to protect speech rights. A bias towards negative rights is evident in Shelby County v. Holder in 2013, where the Supreme Court controversially struck down the preclearance provision of the Voting Rights Act. The Sixth Amendment is arguably both positive and negative. The right to counsel has evolved through cases such as Powell v. Alabama and Gideon v. Wainwright to be a positive right. However, defendants can still refuse the right to counsel or trial by jury if they so choose. From abolitionists to suffragettes to civil rights foot soldiers to high school students in Parkland, Florida, the Bill of Rights have proven essential to expanding American democracy with each generation in hopes that one day all Americans will enjoy a full loaf of freedom and opportunity. Thank you. We're ready for your questions.
Thank you very much. If you wouldn't mind, if you could explain a little more about where you think Shelby falls in negative versus positive rights. Can you expand on that?
Yeah, so I think you're referring to Shelby County v. Holder, I just presume in 2013.
Right, that you just referred to.
Yeah. Yes, exactly. So in Shelby County v. Holder 2013, what that did is removed the Section 2 of the Voting Rights Act of 1965, which removed the preclearance provision. And in terms of negative positive rights, I would argue that that's taking away from our negative rights as something that can't be taken away, and that decision kind of abridged on taking away those rights as voting places around the nation shut down after that. And what that resulted in, as a result, was that minority voting went down across the country. So I think that decision was very harmful. And maybe we should look into the John Lewis Voting Rights Act, proposed, of course, by Alabama's District 7, Terry Sewell.
Well, one of our arguments we make is that voting is one of the few examples of positive rights we have within our country. And I'd argue that although we do say negative rights are more essential to the preservation of liberty, this one positive right, voting, is essential to a democracy. So without it, we could not have these negative rights we hold so dear. So the reason we view voting as a positive right is because the government must extend places for you to vote at. They have to offer this right to you, and therefore we view it as more positive. So the decision in Shelby County v. Holder really almost abridged that positive right.
Yes, I misspoke there. I meant positive. Thank you.
Thank you.
Yeah, but going back to the end of your opening statement, you talk about the Sixth Amendment right to counsel and how it's both positive and negative because you can waive it. Can you explain a little bit more what you meant by how waiver applies here?
Well, the reason that we say the Sixth Amendment is both positive and negative is because the government, and of course, the most permanent example we have of this is Gideon v. Wainwright, where the government is required to extend counsel to you. That is a positive right. However, we just merely wanted to state that you can still refuse this right to counsel. So it is not actually imposing something upon you. It is more of an offer of the government as opposed to a positive right that they give to you.
Right, you have the independent choice to restrict what government can do upon you, and thus in that way it can be interpreted as a negative rights protection from the individual.
Okay, so the waiver itself doesn't apply to whether it's a positive or negative right. It gives you a little bit more freedom in how you respond to the right.
Yes, sir.
Great. Richard?
Yeah, so let's go back a little bit. You're dancing around the issue. How can you lose rights under the Constitution? But I'd like to follow up and have a second half of that question. How can they be earned back? Or can they?
So One example would be felon voting rights. So, and depending on the state, it changes from each one. If you commit a felony, then your voting rights are taken away. And again, it depends on each state, but there are ways to get that back. Whether that's when your sentence ends, or after that's several years after your sentence ends, or if you have to earn them back in a certain way by a certain amount of community service, that's one way in which your right to a vote can be taken away.
And historically, we have seen that rights, especially constitutional rights, can and have been taken away before incorporation of the 14th Amendment, to where the Bill of Rights was applied to the states. You can see in cases such as Barron v. Baltimore, these Fifth Amendment right to property were taken away, and then the court ruled that these these Bill of Rights protections do not apply upon these citizens. And so they can be given back through the 14th Amendment, which was what we see historically, but in that way, they were able to be taken away.
Okay. So what do you think was left out of the Bill of Rights?
Well, of course, Madison ended up with he drew ideas from the states and ended up with a number of amendments that he cut to 12. And then the last two that were not introduced into the original Bill of Rights ended up being the 14th and the 27th Amendments we have today. So to be honest, I do not believe there's anything that or we left out at that time. But of course, in Article 5, we have the amendment process. So if there's anything the country felt should be left out, such as the direct election of senators, was added in later.
Okay. Is there anything else that you think should be the subject of amendments, as opposed to legislation?
I think there's an interesting argument for the right to an education. And we've seen in this recent court case, Cook v. Raimondo, where students are trying to get this right to an education to be a constitutional right, which was previously determined to not be a constitutional right in San Antonio Independent School District versus Rodriguez. And so I think, though that case will most likely not make it to the Supreme Court and most likely would not win in the Supreme Court, I think that's where we might want to see a new amendment and a new right preserved, because we are one of the few countries in the world that does not list education in our Constitution, and the only one that doesn't give education through the UN Convention on Rights of the Child. So I think as we move through the...
Sorry, but if the states all cover education, every state has an education provision, so doesn't that cover it?
It does. I think my argument would be that if we have a federal protection and an overlying protection, we can make sure that any grievances within the states that might not, arguably might not give that fundamental right of education or a right to education, I think that would be protected with a federal amendment.
For instance, just the other day, Virginia announced that they were restricting all accelerated math courses from 11th grade and beyond. So you can only take them if you're in 11th grade and 12th grade. I very much disagree with that. I don't think that should be the case. I think you should be able to take advanced math courses pretty much anywhere in your high school education. So I think if we were to have an amendment like Walt just proposed, maybe we could protect that in a different way than Virginia attempts to.
Also, we have to think about, we have a lot of families that move around the country, such as military families, that would appreciate almost a consistency between states and education. Right now, we have a lot of states have adopted the Common Core standards, but for example, in Alabama, we have the Alabama College Readiness Standards, where I could take U.S. history in 9th grade here, but I would be required to take it in 12th grade in Ohio if I moved. So a federal amendment would hopefully allow a uniformity across the U.S.
But why does it have to be a right? Why does it have to be an amendment? Why can't we just pass a law that does that? What's the difference between something that's good for society versus a right with a big capital R next to it?
You're exactly right. And it's one of the reasons that I don't explicitly argue for this sort of federal protection on education, is because I think we need to preserve our idea of federalism, that the states should have some discretion over or should have more power than they would if this amendment would be incorporated into the Constitution. So I think you're exactly right there, that we could avoid an amendment.
Although the advantage of an amendment is that it gives the courts a much more solid basis to root their ruling in. So rather than putting it into a law, which, as you said, is still very viable in the court, it's much easier and much... May I continue my thought? Or finish my thought? Thank you.
Please.
It's much more established if we were to do an amendment. Thank you, guys.
What a great job.
I have more questions.
What? You had another question?
I
Sorry.
have tons more questions.
Yes, so did
We
we all.
could continue all day.
Well, why don't you start commenting then, Richard?
I'm speechless. That was very good. You guys should all three of you be very proud of the presentation that you gave. Your answers to the questions were staggering. I'm really impressed with the amount of knowledge that you clearly have about this subject. You pulled references to historical events and cases. I don't know where you were pulling them from, but you've obviously done a lot of homework. You did a very good job. You should be very proud, and thank you.
Great. Kurt?
Yeah, I marked down that Ethan's trying to use the military against me. And I also just want to point out that I disagree completely with Carson. I don't believe we should have any accelerated math classes because they all make me feel dumb. So I have much more pertinent notes as well. I thought this was a great conversation. We were able to explore so many things. The one thing, this is my one challenge to you, all right? My one thing is you talk about Australia, but you don't use it to your advantage or distinguish it. So I don't know what you mean by it. Why do you bring it in there? Either pop the balloon or blow it up, and so we can't ignore it. And you can do it in Q&A as well. I think you had one or two opportunities to throw that out against us to use it as both a sword and a shield. Because I love that you started with that. It was a great conversation. I'm nitpicking. You understand that. This was good. I'm just nitpicking you now because I thought it was a great conversation. So thank you all very much.
I thought so too. It was a wonderful, wonderful conversation. Starting out with half a loaf better than no bread was a great start.
Yeah.
Not having heard the phrase that way, that was lovely. And ending with we should vote on the John Lewis Act, which would be great. So the range of thoughts that you had were really impressive, and you just sort of grabbed everything by the. I was going to say something I shouldn't say. You grabbed everything and ran, and it was a real pleasure to listen to you do that. And I know you're all talking about chemical engineering and all this stuff that's way out of range for a lawyer like me. But what I do know is that you're all going to be stunning citizens, and I hope that you'll use this experience to educate yourselves. You'll be reading the newspaper and listening to the news and voting every chance you get, I know, the rest of your lives. But I hope you'll also influence your friends and families to do the same and educate them as you go along. But, we might need some chemical engineers in Congress or in state or local governments too. And we seriously would be in great benefit to have you all represent us in the future. I will sit in my rocking chair in the nursing home feeling a whole lot better if any one of you, much less all three, ends up representing us in Congress or in your state governments, because we need people who know what they're talking about in the government as well as out. So thank you so much. You did a really lovely job. It was a real pleasure to talk with you. Thank you. I hope you enjoyed it as much as we did.
Thank you. That was a lot of fun.
Yeah, thank you guys so much.
Of course.
Thank you. Great job.